When a company engages in a transaction resulting in a change of control, the board of directors is subject to enhanced fiduciary duties. This duty, called a Revlon duty, was first articulated in the case of Revlon versus MacAndrews and Forbes Holdings. The Delaware Supreme Court explored the application of the Revlon duty in C&J Energy Services versus City of Miami General Employees Retirement Trust. C&J Energy Services Incorporated, an oilfield services provider, wanted to acquire competitor Nabors Industries. The acquisition presented a strategic advantage for C&J to capitalize on Nabors' underutilized assets. Under the proposed transaction structure, C&J would merge with a newly created Nabors subsidiary. Nabors, a Bermudian entity, would be the parent company and maintain a controlling interest in the new entity, which would also be domiciled in Bermuda. Both parties agreed that C&J's management team would manage the new entity. This structure would provide C&J stockholders tax benefits worth $200 million. To offset the loss of control, the merger agreement contained several protections for C&J stockholders. First, C&J stockholders could choose the majority of the initial board members. Second, for 5 years after closing the transaction, a 2/3 vote of all stockholders would be required for all major decisions. Third, during that same 5-year period, Nabors would be prohibited from increasing its stake in C&J. Fourth, if significant assets or the whole company were sold, C&J stockholders would be entitled to receive the same pro rata consideration. Finally, the agreement enabled C&J to rescind the deal if a better offer emerged. C&J's board unanimously approved the transaction. The City of Miami General Employees Retirement Trust, a C&J stockholder, brought suit to enjoin the merger. The trial court issued a preliminary injunction enjoining the stockholder vote. The court determined it was plausible that the C&J board violated its fiduciary duties by neglecting to actively solicit alternate offers before agreeing to the transaction with Nabors. C&J appealed to the Delaware Supreme Court.